The Honorable Justices of the Supreme Court. This court from recess now sitting.
Thank you. Please be seated. I will call 126-477 David Vogt versus Kansas Department of Revenue. Will counsel please state their appearances?
Please the court. David Vogt appears by counsel Brandon Davies. We are ready for argument.
Please the court. My name is Charles Bradley and I represent the appellant. Yes, I have no evidence. Present and ready for argument.
Thank you. Mr. Davies?
Judge, before I forget, may I be allowed to have 3 minutes of rebuttal?
3 minutes is allowed, yes.
This case, it started so clean. The issue was confined to basically one sentence, which was under KSA 8-2142 is a diversion for a DUI charge treated as a conviction for a CDL holder for license suspension purposes. That's what the case started off as. And before I can get to the merits of that, which I think are kind of wrapped up all the same issue kind of pops up its ugly head several times throughout this argument. But before I get to that, I think it's important to kind of lay the groundwork for how we got here and then address the Court of Appeals decision. So my client, David Vogt, is a truck driver. He's a truck driver for 30 plus years for a company here in Kansas City. And he ultimately ended up getting a DUI in his personal vehicle. He hired counsel, and that was myself. He was in Kansas. We were under this longstanding belief that a CDL holder was not allowed to do diversion. In fact, there was a law specifically prohibiting it, which was KSA 8-2150. However, at this same time that Mr. Vogt got his DUI, there was an attorney general opinion issued that kind of mucked it up a little bit. The attorney general opinion on the February 10th, 2022, basically come out and said that CDL holders are eligible for diversion, kind of contrary to the law. What that did was create this sense in the people that were actually out there practicing DUI were like, well, what do we do? The law says this, but the AG opinion says this. And some of the city courts and a lot of the courts across Kansas started adopting the attorney general's opinion as basically the go-ahead and give CDL holders a shot at diversion. Mr. Vogt happened to fit in that window in which there was some at least grounds to allow the city courts to expand the scope of diversion and give Mr. Vogt a diversion. He entered into that diversion believing that his CDL wouldn't be suspended, and it was kind of a lucky break, so to say. He entered into this diversion agreement with the city of Olathe, and he performed well on the diversion agreement, had no problems. Ultimately, as everyone knows, when you get a DUI, there's two sides of the case. There's the administrative side of the case where you can lose your license, and there is the criminal side of the case where you can lose your license. We had an administrative hearing. We filed the appropriate notice. He prevailed on the administrative hearing, and there was no penalty taken administratively on his driver's license. So Mr. Vogt was very happy. He had gotten a CDL. He had a CDL. He was saving his job. He had a diversion as well as he had won his administrative hearing and had no suspension on his driver's license. In comes the KDR and sends him a notice saying, we are suspending your driver's license, your CDL, because we believe that a diversion is a conviction, which it categorically isn't, but the state basically misclassified or intentionally classified his diversion as a conviction and suspended his driver's license. Then we filed an appeal in the district court, and a district court judge ultimately determined that Mr. Vogt was right, that the definition of diversion did not meet the definition of conviction, and allowed Mr. Vogt to continue to keep his license. It went to the Court of Appeals, the KDR appealed, and then here we get this decision that no one had ever raised an issue of jurisdiction.
Can I,
Yes,
as it pertains to what the Court of Appeals did,
sure.
was that ever addressed by the Court of Appeals at oral argument, or did this just come as a complete surprise when the opinion was issued?
There was no oral argument at the Court of Appeals. It was completely surprised. And so I think I need to to get to the merits of the underlying argument, I think I need to get past the Court of Appeals decision.
Yeah, you do. And what I'm concerned about, or what you filed a petition for review and didn't mention the Court of Appeals rationale for dismissing the claim. Then I'm looking for briefs to our court telling us why the Court of Appeals was wrong. They're non-existent. So how do we get there? There's nothing before us that tells us why the Court of Appeals was wrong to dismiss the case. So why don't you start there and tell us, what do we do?
So the Court of Appeals basically sidestepped the merits of the case by saying under 20, I'm sorry.
The numbers do get very confusing.
Yeah, there's a bunch of statutes here.
Yeah,
I think it's under 28-255. I think is what they cited, saying if the KDR makes a classification that the person should be suspended under 255 because of 8242. In other words, they get to create a classification of why they are suspending you. And then the Court of Appeals says, because that they've classified it that way and said it is a conviction, that the state we don't have any jurisdiction to hear the appeal.
And why is that wrong?
Because for one, they're allowing the KDR to basically create this bucket of abyss, and they can just they can classify any suspension at all or any driver's license at all. They can just say, we're suspending it because you're a CDL holder and it's a first-time suspension, and then you can't appeal it. There's just
First-time conviction.
First-time conviction. The key operative term in all this that keeps coming up is conviction. They're relying on the same exact rationale. They're not even addressing the rationale. They're just saying because the KDR said it's a conviction that you can't appeal it. So it basically gives the KDR just carte blanche to assign any driver's license and say, you got a suspension based on a CDL and it's a first-time conviction. You fall within this classification, that those classifications aren't able to be appealed. The underlying issue, though, is it's not a conviction. The KDR is calling it a conviction, but it's not a conviction under the statute. And so the Court of Appeals doesn't even address the underlying issue of whether it's a conviction in the first place.
Well, the KDR's reading of the statute is that it is a conviction. You have a disagreement on how you read the statute, but their reading is that it is. But I'm still concerned about how we get there with how this case is postured.
And would you like me to address, maybe it's pertinent to address the differentiation, the interpretation of the statute?
Well, how do we even get to that with how this case is postured with what the Court of Appeals says? We don't have jurisdiction, or the court does not have jurisdiction to get there because it's a mandatory suspension as a result of their interpretation of the statute.
And I agree, that is their rationale. They're saying you don't even get into court to determine whether the conviction is a conviction under the meaning of the statute. Not that's what the Court of Appeals is saying. I think it comes, which is briefed in our brief to the Supreme Court, which it's a due process issue as well. You have this issue of.
Well, you said it was due process, but you didn't really explain it. It's just, you kind of claim it's due process because there's a lack of notice.
In a lack of meaningfully being able to be heard on the facts of the definition of conviction.
Is your argument that the jurisdictional conclusion of the Court of Appeals is really tied to the merits? You can't divorce the two because the jurisdictional conclusion depends upon the panel's conclusion that this was a mandatory disqualification of the privilege to drive a commercial motor vehicle under subsection A2A. And then if you look at A2A, that's where, it's a, first time conviction of a violation of 8-1567. So the merits and jurisdiction are just inextricably intertwined. Is that your position?
It is based on the whole thing is predicated on what is the definition of conviction. The Court of Appeals is relying on saying they've classified it as a conviction, so you don't have jurisdiction to appeal it. But the underlying issue, the classification should be able to, like, whether or not he got a conviction is at issue, but then also the appealing the classification. If we aren't allowed to get into the court to address what the meaning of the word conviction is, then it really just gives the KDR a throwaway bin where they can say anything, any suspension at all, or in any driver's license at all. They can say, we're deciding that we're calling your whatever happened a conviction. And because we're calling it a conviction, the Court of Appeals is saying, well, they called it a conviction, so we're not going to hear it. So the definition of conviction is at the heart of the merit of this case, but then also of, like you just said, of whether or not the Court of Appeals opinion is correct.
The other thing that's absent is the diversion agreement that your client entered into, and what was the result. We have the district court's termination of the case that indicates a paying of $8 of court costs. Is that accurate?
And it is. There was a court cost. There's a diversion fee associated with the diversion that he did pay, which I think that kind of leads into, maybe I'm reading you wrong, but the definition of conviction.
Right.
Yeah.
I'm curious. And was there a fine associated with this?
And there's not, in a diversion, you're not particularly given a fine, you're given a diversion cost, but fines only really apply to convictions.
I understand that.
Yeah.
So, but it didn't classify what was paid as a fine. It's just the cost of the diversion.
I don't think it's classified as a fine, but I'm not going to, I don't know what the abstraction of diversion from the city court says to the KDR, because I don't get that. I realize I only
But
have,
you have the diversion agreement.
excuse me?
You negotiated the diversion, didn't you? So
I did.
There is a diversion agreement somewhere.
There is a diversion agreement.
Go ahead.
And I realize I'm running a little bit short on time, but I just think it's important to, without beating a dead horse, in my original brief to the district court, it lays it out pretty cleanly, the differentiation between the federal regulation and the state regulation. And I think that the entry into the state regulation, including and, changes the entire interpretation of the statute. I will save whatever else for my rebuttal time. Thanks. Unless there's no other questions. Thank you.
Thank you. You may proceed.
Thank you. Under the Kansas Uniform Commercial Driver's License Act, Kansas regulates the licensure of those operating commercial motor vehicles. These motorists must not only possess special skills, but also be held to a higher level of safety than other drivers. For example, 8-2142 requires that a person's commercial driving privileges be disqualified for 1 year upon being convicted of a violation of 8-1567. To ensure that unsafe drivers aren't able to hide their reckless habits, 8-2150 prohibits the masking of moving violations. When facing a traffic violation charge, a diversion or deferment that would prevent the violation from appearing on the driver's record is expressly prohibited. The current case and the treatment of all DUI diversions for all CDL holders is based upon the specific wording used in these statutes. Under KSA 222909, a diversion for DUI in Kansas requires the payment of a fine, as per 8-1567. If you get a diversion for a DUI for a first offense, it has to include a fine in the diversion agreement for $750. A second occurrence, I believe, is $1,500.
Under the Court of Appeals interpretation, how does one contest whether the driver was convicted of a DUI? What if it's, let's just say it was a mistake that the inclusion, that the notice of a conviction was for the wrong person. There's a mistake. But the KDR go ahead and suspends this commercial driver's license. What recourse does a person in Mr. Vogt's position have? It seems like there is none.
Well, fortunately, such an error would never occur, but
Well, no,
under,
I would answer the question. If it did, what's the recourse?
under 8255, a conviction-based suspension can be reviewed by KDOR. The person can submit written request for review. We take a look at it. We check, make sure everything in the abstract is correct, and then we'll send that back to them.
How does that request get made once the determination is made that they're suspended?
We send them a letter indicating that you have been suspended for this conviction that we received, and they, I believe, within 15 days may submit a written request for review, written reconsideration, etc. That there is no hearing, there is no stay of the driver's license suspension, though.
But as a matter of law, would that also include challenging whether a diversion is a conviction? Because you're talking about, look, I want to challenge my conviction. And it's like, oh, was there an administrative error in the abstract sent from the municipal court or whatever it was? But, the underlying legal issue say, to say, what, this was not a conviction. It was a diversion as a matter of law, which doesn't qualify as a conviction.
Well, unfortunately, if it's not a conviction, then 8255 wouldn't apply. And similarly, if it's not a conviction.
That's what he's arguing. It's not a conviction.
And that's why, in order to get to the jurisdiction issue, we do actually have to kind of get to the conviction issue. The Court of Appeals got it completely right. The only issue is that they didn't explicitly say how they got there.
Say that again. They got it right, but they didn't address they didn't address the issue of conviction diversion at all.
Well, they didn't.
They said there's no jurisdiction to hear that because it's mandatory.
In order to get to that determination, they had to get past that first step. Based on Kansas law, a court does not have jurisdiction to review a conviction-based suspension. In this matter, this is a suspension based upon a conviction. And therefore,
So how do you contest whether or not it's a conviction?
The exact same way that they contested it in Wall versus Kansas Department of Revenue. In that case, that I'm going to assume everyone is familiar with our lovely DC 27 suspensions. The driver got a DUI, got a DC 27 notice of suspension, appealed it up. The officer didn't attach the test results. So he said that he failed a breath test, but there were no test results attached. He appealed it up, and KDOR, because they didn't bring it up at the admin level, said, you don't have jurisdiction. You can't bring up this argument. And the Court of Appeals agreed. Said that technically they are right, but KDOR never had subject matter jurisdiction in the first place. KDOR has to take care of at least the bare minimum to even obtain authority in order to take action. And that would be similar to this case. If this court determines that a diversion is not actually a conviction, which I'm pretty sure it is, then unfortunately KDOR does not have authority or subject matter jurisdiction to do anything. But the determination made by the Court of Appeals was that a conviction-based suspension cannot have a petition for review. In order to get there, obviously this is a conviction.
And on the merits of that, are you relying exclusively on the language payment of a fine?
Yes.
Nothing else in, I think it's subsection H of the definitional statute. I guess it's 2128 H that defines conviction.
That is the one that we are most heavily relying on.
Is there anything else?
I don't believe so, Your Honor.
Is this a matter of first impression for us if we reach it? So we don't have a case that construes the definition of conviction, or at least not relying on.
Not like this. No. That this is a matter of first impression on many levels. But again, Under 2909, a DUI diversion in Kansas does explicitly require the payment of a fine. And a conviction of 1567 requires the 1-year disqualification under 2142. Sorry, all of these are chapter 8. Under 2128, definition of conviction includes payment of a fine. Thus, payment of a fine as required by statute and included in the DUI diversion makes a conviction for CDL purposes. And KDOR is required under 8142 to 142 to disqualify the drivers, all drivers convicted of a DUI of their CDLs. To address the lapse and the issues that happened in spring of 2022, the AG opinion in spring of 2022 took this one step further in its logic analysis. They found that because they walked through all of those same steps, and they found that because a DUI diversion for a CDL holder is a conviction, it is recorded on their CIDLIS. That's their commercial driver's license information system. That it's a special driving record for commercial drivers. Because that conviction would actually be recorded, it's not technically masking, and therefore it wouldn't actually violate the 2150 prohibition. And so, using the same logic, their end analysis was actually that DUI diversions can be given to CDL holders for only DUIs, because only DUIs under 2909 mandate the payment of a fine. Unfortunately, this creates kind of a catch-22 for the driver. If they're correct that DUI diversions are not convictions, then is that diversion lawful?
I'm sorry, if they're correct, what?
If a DUI diversion is not a conviction, then unfortunately it wouldn't be recorded on his record, and it would become an unlawful diversion under 2150, because it would then be masking. But if he's not correct and he gets to keep his diversion, then obviously he has to face the suspension.
What if he took community service in lieu of the fine?
Then it would be in violation of 2909, which is precisely why
Well,
only DUIs.
Well, I read in 2909 sub C, which is what we're talking about, that you can pay a fine or perform community service in lieu of.
Is that specifically for the DUI?
Well, I guess that's what I'm asking you,
Okay.
but that's what it looks like to me.
My reading of
That's
the 2909 is
2909 C1. C1 says pay a fine equal to the amount authorized in 8-1567. Or in lieu of payment of fine, perform community. I know that's not the facts, but that's an interesting wrinkle. Does the whether or not this diversion counts as a conviction depend on whether they did community service or paid a fine?
I didn't notice that. My reading, and apparently the AG's reading of 2909, was that payment of a fine was required. Presumably, if they do not pay the fine, then it would be masking.
And again, if we get to this question, can you address Mr. Vogt's position that 8-128H creates two conditions as opposed to one by the use of the word and? And you kind of say it's a typographical error. You give some, but it's there. And if we read it in the way Mr. Vogt reads it, doesn't it create two conditions? One, an unvacated adjudication of guilt or a determination that the person has violated or failed to comply with the law, and you really don't have that first condition. If we read it the way Mr. Vogt encourages us to read it or interprets it. And what's wrong with that interpretation?
From a pragmatic and legislative perspective, I do not believe that was the legislative intent. Unfortunately, I looked at all of the legislative history from 1989 and could not
Yeah,
find anything.
We have two.
I actually asked my superior, who was around in that time, if he remembered this, and he did not.
Well,
That being said, this was adopted almost identical to the federal regulations and almost identical to all the other states' regulations. Now, it does seem odd that Kansas would intentionally put in an "and" if they didn't mean to. But, and I believe in my appellate brief, I did actually go into the syntax and the prepositional phrases therein. I unfortunately do not remember exactly what I said. I do believe that even if you do include the and understand that it was intentionally placed in there, even a proper reading of it, taking out all the prepositional phrases and understanding the intent of it, I believe a clear reading still does indicate that a payment of a fine is a conviction. I do apologize. I don't remember the grammar that was actually analyzed. And admittedly, I don't fully understand all of the grammar. It's difficult.
But basically, to get there, we have to read "and" out, essentially. Is that your view?
I have effectively two arguments. One is that even with the "and" in there, it is still clear that payment of a fine and all of these different things are, all of those different things amount to a conviction. It admittedly.
And I really asked my question very well, because that sounds like an agreement that with the "and" in there, it's two steps. There's two parts. Has to be both what's before the "and" something that is after the "and." If you take that version.
Right.
Is that correct?
Sorry, can I grab the statute so I can?
Yes, yes.
I'm not prepared.
Yeah, well, there's also a statute book, if that helps. But if not, I mean, you're welcome to go ahead with that without looking at it if you want to, but.
Oh, do you have it pulled up? Thanks. They're not supposed to be helping me, so there's the pertinent part. Oh, you got both of them, good. Conviction means an unconvicted of guilt. So my reading is conviction means an unvacated adjudication of guilt. A determination that a person has violated or failed to comply with the law and in a court of jurisdiction or administrative proceeding. That's the second option. An unvacated forfeiture of bail or collateral deposit to secure the person's appearance in court. A plea of guilty or nolo contender accepted by the court, the payment of a fine or cost or court cost, or a violation of condition of release without bail. That's where the commas actually separate things.
Well, on the question of commas, and it's rare that we get cases that turn on commas, but they have happened. Does the fact that the word "and" is not followed by a comma help your argument that this is a mistake?
It does.
It seems to me that it potentially does too, because grammatically speaking, if this were two separate and independent factors, both of which had to be met, the word "and" ought to be followed by a comma, right?
Yes.
To describe the phrase in a court of an original jurisdiction or administrative proceeding. Is that how you read it?
It is, and that is correct. And that's why each of those are somewhat parsed out the way that they are. Correct.
Are there other questions? Summarize if you wish. I think I took up lots of your time.
Sorry, I wanted to make sure I did hit on my points, but again, finally, we do believe that the Court of Appeals came to the correct decision, but based upon the predicate that a DUI diversion for a CDL holder is a conviction.
Okay, thank you. Mr. Davies?
Let's address a couple of quick things. And then, so the KDR said that when it was proposed by Justice Stiegel, if under 255, how would somebody contest the suspension? They can't. They can go through they can ask KDR to reconsider, but there's no mechanism. That's why we're here. And they also said that a mistake like that would never happen as a joke, but that's exactly why we're here, is because they've misclassified. To say that we would never misclassify somebody's driver's license, that's exactly why we're here, because they misclassified a diversion as a conviction. And, you know, I think it's important. If you look at the AG's opinion, they get it wrong. Then if you just look at the simple language of the AG's opinion, they quote directly 49 CFR 383.5 exactly like it is KSA 8/2128. Nobody read it. If you look at CFR or 49 CFR 383.5, it's not just and. There's several words changed between that and KSA 828. Now,
Is that the heart of your argument that it's not a conviction?
it is not a conviction.
Just spell that out for me. Why is a diversion not?
So if you look under the definition of conviction for 8/2128, why your comment to the comma is important. Also, but that's why I'm saying it's not just one singular word that's changed. It was by design. They changed several words. Somebody looked at this and said, "This is what we're going to do different."
Just focus on the language of the.
Sure. So on 8/2128, an unvacated adjudication of guilt. Okay, that is if the KDR determines you have that is a conviction. Then they can suspend your driver's license, or a determination that a person has violated or failed to comply with the law. Okay. If you think about that practically, what does that mean? That's some sort of determination that you violated the law. Let's say they don't have an abstraction of conviction sin, but we have some sort of plea or something that you've done that we can show there is a violation of the law. And then it says, and as if we're not going to rely on just a determination that you violated the law. We want some sort of extrinsic proof that validates that you have had this determination of guilt. One of those things would be like paying a fine. Like if the court had a random fine paid, but they didn't have an abstraction of conviction, they could say, is there a finding of guilt through some sort of other documentation? And then there was a fine that would validate I guess, or give credence to the fact that there wasn't a determination that the person violated or failed to comply with the law. All of these in a court of original jurisdiction or administrative proceeding, an unvacated forfeiture of bond or collateral deposited to secure a person's appearance in court. Those are all like extrinsic proof that you've done something that validates a finding that you've done something wrong. A plea of guilty, obviously, if they didn't have an abstracted conviction to the KDR, but there was a plea form.
Your argument is you need both the adjudication of guilt plus some indicia, something else that proves the adjudication.
And I think that's what that makes sense when looking at.
And I understand that argument. Just indulge me 1 second. Would you agree or disagree that just purely as a matter of grammar, reading the statute the way you asked us to read it, it's a grammatical error not to follow the word "and" with a comma?
And I went to, my undergrad was political science, not English. So I'm not gonna opine on,
Okay.
I would agree with you that when I read it, I thought, well, that could use a comma there. But then when I look,
Then my last question is, let's just say for purposes of the question, we agree that that's a grammatical error. Is that relevant? Does that tell us anything about how to read the statute?
I don't think so. I think if you read it as it's plainly laid out, and it just try to assign some meaning to why someone would do it this way. I think it lays out just like I just laid it out.
Okay.
Thanks for your time. Unless there's no other questions, appreciate it.
Thank you. Thank you to both counsel for your arguments in this matter. The court will take this case under advisement. We are now in recess until 9 a.m. tomorrow.